Good morning or good afternoon. I'm going to wait just a minute. I can see everybody joining. Make sure everybody has gotten on. All right, it looks like everybody's joined. Good morning. My name is Alice Vickers, and I'm with the Public Interest Law section of the Florida Bar. Welcome to our lunchtime webinar, Mobile Home Park Law 101, Affordable Housing Advocacy in Florida. This webinar today is provided by the Legal Services of North Florida and the Consumer and Tenant Rights Committee of the Public Interest Law section of the Florida Bar. Our section will soon be known as the Equal Justice section, but we will continue the good work that we've been doing for the past 25 plus years, just under a new name. Our webinar today is being recorded, and the webinar, the PowerPoint, and the CLE information will be found at flpublicinterestlaw.org. And on that website, you can also find information about joining the Public Interest Law section. We encourage you to join if you're not already a member. The fee is only $35 a year, and it supports our section and the work that we do, and we provide a lot of information for our members and for others. As just a point of housekeeping, I just want to say that everyone is on mute, but if you have a question, please type it into the appropriate box in that right toolbar, and if we have time, we will answer the questions at the end. I'm happy today to that our presenter is Nejla Calvo. Nejla is an attorney with Legal Services of Greater Miami, and we thank her for volunteering her time to present this webinar. Nejla graduated from Middlebury College and University of Miami Law School. Upon graduation, Nejla was awarded an Equal Justice Works Fellowship. Hers was the first ever staff-selected fellowship, competing with many others around the country. And her 2-year project, which she did at the Legal Services of Greater Miami, was to work on protecting the rights of residents of mobile home parks in Miami. Nejla currently leads the Mobile Home Park Advocacy Project at LSGMI, and the project's ultimate goal is building the capacity of mobile homeowners associations to provide residents with the full protections under Florida law. Nejla, I'll pass it off to you now.
Thank you for the introduction, Alice. I'm really excited to spend this hour with all of you and talk about the exciting work in mobile home parks and the law and legal issues that come up with mobile home park tenancies. I'm just going to take a moment and point your direction to the bottom of the screen there. My email address is there, ncalvo@legalservicesmiami.org. So please feel free to reach out to me if there's any questions regarding this webinar, or if you come across mobile home park issues in the future. I'm always open to brainstorming with other public interest attorneys throughout the state. So I'll jump right into it because this is going to cover a lot of different issues. I can't delve into full detail on all of the issues, but I wanted to give an overview of the Florida Mobile Home Act and some of the most common legal issues that arise in mobile home parks. So this is the outline. We'll talk about mobile home park tenancies generally and why it's the focus of my project and why it's so important in Florida. The rights and obligations of homeowners under the Florida Mobile Home Act, as well as park owners. Evictions and defenses under the Florida Mobile Home Act, park closures and park sales, which we're seeing a lot of these days here in South Florida, and improper rent increases and improper decreases in park services, what rights residents have in those situations, the importance of homeowners associations under the Florida Mobile Home Act, the DBPR Division of Mobile Homes and what their powers and duties are, and finally, consumer practices for buying a mobile home. So let's just dive right in and talk a little bit about mobile home park tenancies. Mobile homes are the last form of affordable, unsubsidized housing in Florida. I make that statement a lot and I stand by it. And this is because mobile home parks are The lot rents in mobile home parks are much cheaper than average apartment rents and home rents. It's a hybrid type of ownership where the the owner of the home owns the home, is on the title of the home, hopefully. We'll talk about title issues, but owns the mobile home and rents the land that the home is situated upon from the mobile home park owner. So it's a hybrid type of ownership. They don't own the land that their home is on, but they own the home. There's approximately 850,000 mobile homes in Florida, which accounts for almost 12% of the total housing units in the state of Florida. And like I mentioned before, the lot rents average in Florida for mobile home parks are about $400, whereas a two-bedroom unit average is $903. So you can see it's less than half the amount. And mobile homes usually house anywhere from 2 to 6 people. It's just not comparable as far as affordability to any other types of housing. And these are some photos of mobile home parks in Miami. A lot of times, at least the mobile home parks in Miami are a bit run down, but they are a source of affordable housing for the working poor, for low-income families. As opposed to in other parts of Florida, such as the Florida Keys, you'll see retirement communities that are well run and that house elderly folks. A lot of these communities are 65 plus in age or 55 plus in age. So the residents in mobile home parks, like I mentioned, include elderly people, disabled folks, retirees, immigrants, families, working poor. There's some parks in rural areas of Florida that house migrant farm workers. So no matter how you look at it, a lot of the residents in these parks are vulnerable populations. And this can give rise to an unequal power dynamic when park owners own the land and homeowners, often vulnerable, own their homes and rent the land. It's kind of like modern day feudalism. Uh, Another vulnerability about mobile home parks is that they are easily developable tracts of land. So right now in South Florida, in Broward County, in Miami-Dade County, and in Monroe County after the hurricane, we're seeing a lot of park closures, park sales, and a lot of these parks are slated for development into some kind of other use. So some legal issues that arise in mobile home parks include evictions, of course. Even though they're mobile homeowners, these homes are not necessarily mobile. So when folks get evicted from a park, it's very difficult for them to take their homes with them. And I'll get into a little bit more about that in the eviction section. We see code enforcement issues in mobile home parks, and code violations can be attributed either to the homeowners if the code violation pertains to the mobile home structure, or to the park owner if the code violation pertains to the common areas of the park or the utility systems within the park. And this can be local building departments, fire departments, and health codes that can be violated lots of times in mobile home parks. We also see improper rent increases and decreases in park services. We'll talk about that in more detail. As I mentioned, park sales, park closures, abuse of power by park owners and management, and title issues. So the substantive law is, of course, Chapter 723 of the Florida statutes, which is called the Florida Mobile Home Act. This governs the rental of mobile home lots in Florida. The Florida Mobile Home Act was developed as in 1985. It used to be a chapter within the Landlord-Tenant Act, which was Chapter 83 of the Florida statutes. But because mobile home tenancies are so unique, the legislature decided to create a whole new chapter to deal with these kinds of tenancies. And this chapter applies to parks in which 10 or more lots are offered for rent. It covers the tenancies of mobile homes or park trailers on a mobile home lot in a mobile home park. Other landlord-tenant relationships are governed by Chapter 83, which is the Landlord-Tenant Act. And if a tenant rents the home and the lot, that's covered by 83. That doesn't get the protections of Chapter 723. So we're talking about mobile homeowners who own their home or park trailer renting a lot from a mobile home park where there are 10 or more lots offered for rent. That's when the Florida Mobile Home Act comes into play. So the first step when you see someone who says they live in a mobile home park is to make sure that they actually own the mobile home or that it is a mobile home or a park trailer. And the best way to determine that is to look at the certificate of title. This is an example of a certificate of title to a mobile home. If the body type is HS on the mobile home title, then it is for sure a mobile home. That's how the Florida Division of Mobile Homes designates mobile homes versus other types of recreational vehicles or trailers. And the definition of the mobile home is found at 723.003 subsection 8. It goes by dimension, so 8 body feet or more in width, over 35 body feet in length, including the hitch. Believe it or not, a lot of folks don't actually have title to mobile homes. They'll buy the home. It could be on a handshake. It could be on a napkin contract. And so that can be troublesome to try to figure out what kind of home it is. Sometimes it is necessary to actually measure the home and see what dimensions you get, and you can try to figure out whether or not it's a mobile home or a park trailer or some sort of other RV. The definition of park trailer and park model is found at 320.01 subsection 7. It's kind of a long definition, but the major points there is that it's a body width not exceeding 14 feet, built on a single chassis, and a transportable unit. There's lots of other types of trailers. There's fifth wheels, there's travel trailers, there's campers, and those would be considered recreational vehicles or RVs, which would not be covered by the protections of the Florida Mobile Home Act. If there's an RV in a mobile home park, but on an RV lot, they may not have the protections of a mobile homeowner. And so the definitions of which chapters would apply in those types of tenancies, you would find at Chapter 513 for RVs. But if it's an RV that's been living in a park or occupying a space in a park for over 6 months, it would be considered a non-transient guest. And for evictions, Chapter 83 would apply. So for understanding the Florida Mobile Home Act, there's a really great resource by James C. Hauser, the Florida Residential Landlord Tenant Manual, Volume 1A, Chapter 8, Mobile Homes. This is published through LexisNexis, but he also has some great secondary sources that you could find on Westlaw. So I highly recommend this resource if there's a certain mobile home issue that you want to read up on. So jumping right into rights and obligations of homeowners and park owners under the Florida Mobile Home Act. The general obligations of the park owner is to comply with building, housing, and health codes, maintain common areas safe and clean, provide access to common areas at all reasonable times for the benefit of park residents and guests, maintain utility connections and systems for which the park owner is responsible. That can get a little complicated because sometimes prospectus agreements may put some responsibility on mobile homeowners for maintenance of utility connections and systems. And number 5, comply with the park rules and regulations and require other persons on the premises with the park owner's consent to comply with rules and regulations and to conduct themselves in a manner that does not disturb park residents or constitute a breach of peace. That provision is very important for counterclaims and evictions, especially if park management or park owners confront mobile homeowners in mobile home parks in a harassing manner or, believe it or not, in a violent manner. This happens sometimes. So I like to bring counterclaims under this provision. Before I jump into the next slide, I did mention something called a park prospectus. The prospectus agreement is something that that includes the rules and regulations of the park and also includes basically all of the terms of tenancy for residents within the park, including the park owner's responsibility as well. So the prospectus agreement, I'm going to explain to you how to find that. It's a public record. You can pull a prospectus agreement for any park. Residents are supposed to have copies of this, but oftentimes they don't. So whenever you're looking at a conflict in a mobile home park, Chapter 723, the Florida Mobile Home Act, is very important, and that definitely rules the tenancy, but so does the park prospectus. So it's very important to understand that that document exists. Okay, so general obligations of mobile homeowners. Mobile homeowners have the obligation to comply with building, housing, and health codes, including compliance with all building permits and construction requirements for construction on the mobile home and lot. This mostly arises when mobile homeowners may want to build an addition on their mobile home or any kind of attachment on their mobile home, maybe an extended patio. At least in Miami, we see that these are often done without the proper permits. They're done by the folks themselves instead of contractors. And if the building department or the fire department, does a sweep in a mobile home park, they can cite the homeowner for that illegal addition if it's done without permits. And the homeowner is responsible for all fines imposed by the local government for noncompliance with codes. For fire code violations, it's usually due to setback requirements. When folks build additions on their mobile homes, this shortens the distance between mobile homes, and it may violate the setback requirement from the mobile home sight line to the actual structure itself. So that would be a fire hazard, and a fire in a mobile home park could spread faster if the homes are closer together and built with combustible materials. We're seeing a lot of sweeps throughout Miami when it comes to code violations. Okay, number 2, keeping the mobile home lot clean, neat, and sanitary, and maintaining compliance with all local codes. Number 3, complying with the park rules and regulations, which can be found in the prospectus agreement, and requiring other persons on the premises with his or her consent to comply with the rules and regulations and conduct themselves in a manner that does not disturb park residents or constitute a breach of peace. So all of these responsibilities can be a basis for eviction if the mobile homeowner does not comply, but we'll talk about the process for eviction. Right to peacefully assemble. Homeowners have a right to peacefully assemble in an open public meeting for any lawful purpose at reasonable times in a reasonable manner in the common areas or recreational areas of the mobile home park. They have a right to communicate or assemble to discuss any problems relative to the park. Park owner may not unreasonably restrict the use of any facility when requested. So this means if the homeowners want to meet in the common room of the park owner can't refuse to allow them to meet. If the homeowners want to meet in the parking lot of a mobile home park, the park owner cannot break up the meeting. Quick little war story. I do go out to mobile home parks quite a bit, and I assist folks with their legal right to form homeowners associations. And I've been out there meeting with folks in the hot sun, and the police have rolled up probably about 3 times in the past 3 years because the park owner or park management does not want a meeting to occur. And I just show the policemen this statute, and I explain to them that the homeowners have a right to assemble, and nothing's ever come of it. But if homeowners don't know this right, then they may be scared to organize, and that could chill their ability to exercise their rights. Park owners' access to mobile home and mobile home lot. This is a really important one because it's violated a lot. The park owner has no right of access to a mobile home, meaning the inside of the mobile home, meaning any part of the structure of the mobile home, unless the mobile homeowner's prior written consent has been obtained, or unless to prevent imminent danger to an occupant of the mobile home or to the mobile home. If there is a fire and the mobile home park manager needs to go wake up an occupant in the home, sure, that in that case they can go enter the home. But if they don't have written consent from the homeowner, they have no right of access to enter into a home. And you'll see this occur when a park manager wants to go check and see whether or not there are unoccupied unauthorized occupants within a mobile home. They'll knock on the door, they'll ask if they can go look around. The mobile homeowners need to know that they do not have to give that consent at all. The mobile home park operator has no right to enter a mobile home without the consent of the homeowner or without having to prevent imminent danger. Now, the mobile home lot, the park owner does have a right of entry onto the lot for the purpose of repair and replacement of utilities and protection of the mobile home park at all reasonable times, but not in such manner or at such time as to interfere unreasonably with the mobile homeowner's quiet enjoyment of the lot. Down in the Florida Keys after Hurricane Irma, this provision came into play quite a bit because park owner in a specific park was using the cleanup after the disaster as a reason to be able to go onto mobile homeowners' lots at all hours, with workers being loud, being disruptive. That's not okay under this statute. They can go at reasonable times and in a manner that does not interfere with the homeowner's quiet enjoyment of the lot. And they may need to do so to read water meters, to read electric meters, to empty septic tanks if it's located within a sight line, but it has to be done reasonably. Obligation of good faith and fair dealings. Every rental agreement or duty within this chapter imposes an obligation of good faith and fair dealings in its performance or enforcement. Either party to a dispute under this chapter may seek an order finding that the other party has not complied with obligations of good faith and fair dealings, and upon such finding, the court shall award reasonable costs and attorney's fees to the prevailing party for proving the noncompliance. This can mean virtually anything, and so it's always good to raise this. If there's any inclination of bad faith on behalf of the mobile home park owner, if they bring an eviction and it seems retaliatory, which is another defense to an eviction, or if by the relationship between the parties you see that there's some instance or pattern of bad faith, then you can bring this as a defense to an eviction, as a counterclaim, or you can bring it as an affirmative action, and you would be entitled to it. The prevailing party is entitled to attorney's fees in enforcing this provision. Speaking of attorney's fees, another statute that applies to pretty much the whole act is that, except as provided in 723.037, which is a specific statute pertaining to rent increase disputes. We're going to talk about that in a bit. In any other proceeding between private parties to enforce provisions of this chapter, the prevailing party is entitled to a reasonable attorney's fee. So that's some inspiration to be able to push a little bit more the enforcement of this chapter. Evictions and defenses under Chapter 723. Mobile home park tenancies, I like to describe, are basically perpetual tenancies. There is no lease term. Sometimes mobile home park owners will have residents sign initial leases, but even if it's only, it says that there's a lease term of 1 year, that doesn't really mean anything, because for as long as that mobile homeowner is abiding by the rules and regulations of the park, for as long as they are there and paying rent, they have a right to remain. The only reasons they can be evicted are for the 5 enumerated reasons that are laid out in Statute 723.061. Which we're going to go through all of these types of evictions and defenses to these evictions. So the first one is non-payment of lot rent. The second is a criminal conviction that affects health, safety, or welfare of other residents. The third type of eviction is a violation of the park rules or rental agreement. And there's different kinds of processes. If it's a serious violation that endangers the health, safety, or welfare of other residents, that's a non-curable violation, or a minor violation where that the homeowner would have the opportunity to cure. The fourth reason is a change in use of land, usually a park closure, but sometimes it's just a portion of the park that may be changing the use of the land. And 5, the failure to obtain park approval to become a tenant. So these are the only reasons that a mobile homeowner can be evicted, not for expiration of a lease term. And evictions, just like under the Florida Landlord Tenant Act, Chapter 83, also under Chapter 723, are summary procedure. So when a mobile homeowner is served with an eviction complaint, they have 5 days to respond. And discovery is abridged, but you do get depositions. Okay, so the first type of eviction for non-payment of lot rent. Lot rent in mobile home parks is monthly usually, and it's sometimes includes water and sewer, sometimes that's paid separately. All of that would be laid out in the prospectus agreement. So it's important to know what's included in lot rent. Because mobile home park owners, excuse me, cannot evict for other monetary fees that are owed to a mobile home owner, only for lot rent and what's included in that amount. It's a very important distinction. Someone might be behind on water bills, but that doesn't necessarily mean that they would be subject to eviction for the non-payment. So the defenses, well, first, if a mobile home park owner wants to evict for non-payment of rent, they have to first provide 5 days notice under 723. And if the mobile homeowner pays the lot rent owed within those 5 days, the park owner cannot move forward with an eviction. If the park owner accepts partial lot rent within those 5 days, that is waiver. They cannot move forward with the eviction. And a lot of times, landlords' attorneys are very familiar with Chapter 83 evictions, not with Chapter 723 evictions, and they'll serve a 3-day notice instead of a 5-day notice to pay rent. That is a defective notice and a basis for a motion to dismiss. So as I mentioned, defenses include payment to the park owner. Acceptance is common law waiver. Tender to the park owner. Sometimes mobile homeowners would have been attempting to pay their rent on time within the 5-day notice period, or even before the 5-day notice period, and the park owner is refusing to accept the rent as an excuse and means to get the homeowner out by an eviction of non-payment of rent. Of course, that would be a defense to the eviction. Material non-compliance by the park owner, which means if the park owner has not complied with, it's actually very general, any provisions, any of their obligations under the Florida Mobile Home Act, then that is a complete defense to a non-payment of an eviction for non-payment of rent. But the homeowner has to send a proper rent withholding notice, which is a written 7-day notice of rent withholding before withholding the rent from the park owner. And actually 723.063 subsection 1, defenses for non-payment of rent, provides a process for where the homeowner can withhold rent. If the park owner brings an eviction, the homeowner will have the defense of material non-compliance, and then the judge is supposed to determine a diminution of value for that rental period and could order that the homeowner is not required to pay full rent for the time that the park owner was in non-compliance. I've yet to see a case where this actually happens, but I'm hopeful that we'll be able to use this provision one day. Improper service of notice. This gets them every time. You have to serve a notice of eviction, any kind of notice of eviction, by posting on the mobile home and via certified mail return receipt requested. Hand delivery does not count. Just posting does not count. It has to be both. And so if there's no certified mail return receipt requested, it is a defective service of notice and it is a basis for a motion to dismiss. Deposit all past due rent, costs, and fees into the court registry. There's a provision that states that if the mobile homeowner deposits everything that's owed, including attorney's costs and fees, into the court registry, and this is the first time that the homeowner is being evicted for non-payment of rent, then they are given a chance. The court is allowed to allow them to stay, even if they were behind on rent, and as long as they deposited everything into the registry. We're going to talk also about registry deposits for all of these types of cases, but it's important to note that for evictions of non-payment of lot rent, the homeowner has to deposit the unpaid rent into the court registry within the 5 days of receiving the complaint, or if they dispute the amount that the 5-day notice is asking for, they have to file a motion to determine rent. And they have the obligation of depositing ongoing rent as it becomes due into the court registry, or they waive all their defenses to the eviction. The second type of eviction from a mobile home park can be for a criminal conviction. So defenses, it has to be a conviction, not an arrest, not charges. It must be a conviction. And the criminal activity must be detrimental to health, safety, or welfare of other residents of the park. It's super unclear what kind of criminal violations would fall under this, but there's arguments that could be made on a lot of different points here. I mean, if someone is convicted of, let's say, check fraud, is that something that affects the health, safety, or welfare of other residents? Not necessarily. There's an argument to be made there. If somebody is convicted of criminal activity from before they became a tenant in the park, arguably that may not be detrimental to health, safety, or welfare. So there's a lot of gray area where arguments can be made. The notice must give 7 days to vacate. So if it doesn't give a full 7 days, then it would be defective. I've seen notices that gave someone 48 hours to vacate the home that they own. That's defective. The notice must be specific enough to articulate a defense. It can't just say that you have been convicted of criminal activity. It has to go somewhat further so that the homeowner would be able to articulate a defense. So it has to state which criminal activity, how it is detrimental to the health, safety, or welfare of other residents. If a park owner serves a notice to vacate and then accepts payment of the lot rent, that's common law waiver. And again, this type of notice has to be served by posting and sent via certified mail return receipt requested. Okay, so for cause evictions, there's two different types. The first type is the more serious type of violation of the rules or regulations of the mobile home park or of Chapter 723 of the Florida statutes. These are non-curable violations, so that must be an act that endangered the life, health, safety, or property of park residents or employees or the peaceful enjoyment of the mobile home park by its residents. In these cases, the park owner can terminate the tenancy with 7-day written notice to vacate without an opportunity to cure. It has to be a properly promulgated rule or regulation of the park. This means that if there is a rule that the park is enforcing, you have to make sure it was actually added to prospectus in a correct way. If it was there from the beginning and the prospectus was approved by the Division of Mobile Homes, you can assume it was a properly promulgated rule. If it's a new rule that the park owner implemented without going through the proper ways of implementing a change in rules, which I'll explain, but they basically have to give 90-day notice to all homeowners, give the homeowners an opportunity to object to the rule change, and then the rule change can go into effect. Sometimes what we see is park owners rewriting all the rules and posting it and claiming that that's the correct rules for the mobile home park, trying to evict people based on those rules, but they may not be properly promulgated. Under the statute, they have to be. And also, in the statute, there's language for this type of eviction that says it's an act that is found by any court of competent jurisdiction to have been an act that endangered the life, health, safety, or property. I think there's an argument to be made that that's a condition precedent to the eviction. Plaintiffs' attorneys, mobile home park operator attorneys will claim that the court of competent jurisdiction is the court that will be handling the eviction. But the way that statute is worded, I think there's a good argument to be made that that court of competent jurisdiction needed to have made that determination before an eviction. If anyone wants to talk about that more, feel free to reach out to me, and I'd be happy to send some sample pleadings that we've been successful on regarding that argument. So defenses to evictions for endangerment, non-curable violations. As I mentioned, failure of condition precedent, the notice has to provide 7 days to vacate. If no court of competent jurisdiction found it to be an act that endangers, then there's an argument that the eviction should have been curable. or I'm sorry, the violation should have been curable, and the homeowner should have been provided an opportunity to cure. The notice has to be detailed enough so the homeowner knows what the alleged violation is. And this isn't written in the statute, but case law in Florida shows that there's kind of this egregious factor. This violation has to be so bad that it warrants the taking of a person's home away, because that's really what will happen in this type of eviction. So, what does it mean to let's see here, endanger the life, health, safety, or property of the park? Well, endangering the property of the park could be, take an example of one of my cases, damaging the entrance to the mobile home park because the gate was not working properly. Does that endanger the property of the park? Sure. Is that enough to lose your home? I don't think it's egregious enough. I think there may be an opportunity to cure there if you pay for the damage, and you just don't do that kind of thing again. So there's always an argument for an opportunity to cure, in my opinion. Speeding in a mobile home park, 10 miles over the speed limit. Sure, that endangers the life and safety of residents. Is that enough? Is that egregious enough to be non-curable? Another defense is waiver by acceptance of the rent payment. Believe it or not, mobile home park owners continue to do this all the time. They just want their money. So they'll be trying to evict someone and still accepting rent payments. And that's common law waiver. We've won summary judgment on that argument. Cannot be arbitrary enforcement of the rules. This is a great defense. A properly promulgated rule or regulation may not be arbitrarily applied and used as a ground for eviction. Case in point is let's say two residents, let's see here. What would be a non-curable violation? Let's say two residents pull a gun on one another in a mobile home park, but the park management wants only one of them to leave, and they file an eviction on just one of those residents. Well, a defense would be that you can't only enforce the rules against you can't arbitrarily apply the rules to evict someone. That's a terrible example. I've never seen that happen before. I was just trying to think of an egregious offense. But what happens more is with curable types of evictions, where maybe there's an addition on a mobile home and they have an issue with this one person, and they know that they didn't get building permits for that addition on the mobile home. So they'll try to single that person out and use the addition as a pretext to get this mobile homeowner out, where 5 of their neighbors also have illegal additions on their mobile homes, and the park is not enforcing the rules against those neighbors. If you can prove that, then you have a really good defense to an eviction. Again, improper service, violation of obligation of good faith is a defense if there's some sort of inclination that a person is being singled out for the rule violation. And retaliatory eviction, which I think, oh, okay, I don't have a slide on that, but that's a really great statute. So a mobile home park owner cannot discriminately enforce rules against a mobile homeowner or discriminately increase someone's lot rent in a retaliatory manner. And examples of actions that park owners may retaliate against, which are actually detailed in the statute, would be participating in a mobile homeowners association, participating in a homeowners committee to dispute a rent increase, and believe it or not, multiple instances of park owners filing evictions, bogus evictions, finding any rule violation, and filing evictions against board of directors that was just elected in a mobile home park. It's retaliation for the homeowners to who want to exercise their rights. The leaders in the park might be singled out, and there's a defense to those types of evictions if you can show that it's being that the eviction was filed in retaliation for organizing. A mobile home park operator can also retaliate against a mobile homeowner for complaining to code enforcement as well. So this other type of rule violation eviction are the kind of curable violations. As I mentioned before, I believe you can make an argument for most violations that they should be curable. But there's some easy ones like unauthorized guests, unauthorized pets, failure to maintain the lot in a clean and sanitary condition, noise violations. These things do not endanger park residents, their life, health, or safety. So they're curable types of violations. The park owner must notify the mobile homeowner within 30 days after the park owner has knowledge of the first violation. And the first notice must provide the mobile homeowner 7 days to cure the violation. If the violation goes uncured, or if within 1 year the mobile homeowner commits the same exact violation, not a similar one, a same exact violation, then the park owner can serve a 30-day notice to terminate the tenancy and the mobile homeowner to vacate. After the 30-day notice expires, then the park owner can file an eviction. This is a pretty, this is statutory, so this is strict compliance, and we see this get messed up all the time. A park owner may serve a notice, a 7-day notice to cure for a party with loud music being played, and then subsequently serve a 30-day notice of termination for a second rule violation because the homeowner had a loud motorcycle in the park. Those are not the same violations. They have to be exactly the same. Sometimes the park owners serve several notices to cure, and then they go ahead and file the eviction. Well, you have to serve a 30-day notice of termination before you can file the eviction. So these are all defenses, which would be failure of condition precedent. The park owner must follow that statutory process to a T. They have to provide an opportunity to cure. They have to detail the violations. Arguably, they have to detail the approximate date, time, and who was involved with the violation so that the homeowner can articulate a defense. It has to be the same exact violation. I know I'm harping on that, but it's very important because that's what the statute says. The waiver by acceptance of rent payment, again, improper service of notice, arbitrary enforcement of the rules, retaliatory eviction, violation of obligation of good faith. And I know I'm going through this really quickly, but I'm trying to give you all of the statutes here in this PowerPoint so you can refer back to them and kind of see how they interplay when it comes to eviction and defenses. Okay, the fourth type of eviction is for change in use of land or a park closure. In these types of evictions, a park owner has to provide 6-month notice prior to the change in use. And as I mentioned, this can be the entire mobile home park, or this can be even one lot. And they don't have to have a reason to change the use in land. They just want to do it. They just have to serve the 6-month notice. There was a case, I forget which circuit's out of, but there was a case where a mobile home park operator wanted to change one of the lots to expand their own personal yard because they actually lived in the park. And that was a permissible reason for a change in use. It's the park owner's land. So unfortunately, they have the power to do that as long as they follow the correct statutory process, which is a 6-month notice. And the notice must include the statutory language about the Florida Mobile Home Relocation Corporation assistance. The link is here. That kind of goes through the process for how to get that assistance. But if the mobile homeowner, they have the ability to apply for this assistance in this situation. If they're able to relocate the home out of the park, then they get $3,000 for a single wide, $6,000 for a double wide. If they're not able to relocate the home and must leave the home behind, they only get $1,375 for a single wide and $2,750 for a double wide. And to be eligible for the assistance, the mobile homeowner has to have the title to the home, and they cannot owe any rent to the mobile home park. This is absolutely terrible numbers. At least in Miami, it's just not doable. Folks buy their homes for anywhere from 15 grand up to 50 grand. And then this is what they get if they're served with a 6-month notice. You know, for a single wide, $1,375 if it can't be moved. The cost of moving a mobile home, the average cost is over $10,000. So this is pennies compared to what the actual cost of moving is. So it's not great. But we can talk about, you know, advocacy and how to get around this statutory amount. which we've had some success with homeowners associations and negotiating group settlements in the cases of park closures that exceed the statutory amount. If a homeowner or homeowners get if they get a 6-month notice of change in use of land, they have to object by petitioning for administrative or judicial remedies within 90 days of receiving the notice, or they are barred from taking any subsequent action to contest the change in use. What does petitioning for administrative or judicial remedies mean? That's a really great question. I arguably you can file a complaint with the Division of Mobile Homes within that deadline, but a surefire way of meeting that requirement is for the homeowner or the homeowners to file for a deck action or an injunction in court. If they can articulate any kind of objection to this change in use of land, usually it would have to connect with violation of obligation of good faith. But there's also another defense under the Act for a park closure, change in use of land eviction, and that is if the government, the local municipality took any action, any official action, which is very vague and broad, including approving an application for rezoning, which would result in the removal of homeowners without first determining that adequate mobile home parks or other suitable facilities exist, that would be a violation of the chapter. So that can really snag up the process of a park closure. If you have a local municipality that is taking any action that leads to a park closure, they have to do a study first, a relocation study, to determine where mobile homeowners can relocate to. They would have to look at mobile home parks, maybe affordable rental situations, but that is a statutory requirement. So sometimes government will take action and it'll be simultaneous with the notice of park closure, and that will give a hook for homeowners to object. Okay, the final type of eviction is failure to obtain park approval to become a tenant. Mobile home residents move in all the time. They buy the homes from one another, right? So let's say someone is selling their home, somebody else buys it, and they go ahead and move in. That they could be the purchaser, the new occupant of the mobile home, could be subject to an eviction if they didn't apply for tenancy first with the mobile home park management. So if mobile home park operator finds out that somebody is now owning and living in a mobile home and didn't obtain park approval first, then the park owner can serve a 7-day notice to vacate to that new occupant. But the Mobile Home Act also states that a park must approve an application if a buyer qualifies and cannot unreasonably withhold approval. So if this person just failed to apply, but their credit is fine, they don't have a criminal history, and they would meet all the requirements for entry into the park, then the park owner cannot unreasonably withhold that person from becoming a tenant in the park. Okay, mentioned this before, but registry deposits during evictions for mobile home park tenancies. If it is an eviction for non-payment of lot rent, the homeowner must deposit unpaid rent into the court registry or file a motion to determine rent and request hearing within 5 days of service of the complaint. They have to attach proof of whatever their argument is to the motion to determine rent. If it's I paid it and or I partially paid rent, they accepted it, they have to attach proof of the rent receipt or of the a picture of the money order, the check, something. And even if you file a motion to determine rent within 5 days of service of the complaint, if you're only disputing a certain amount that the park owner is requesting in the 5-day notice, the best practice is to deposit the undisputed amount into the registry, because if you fail to meet the court registry deposit requirement, then a defendant in eviction can waive all of their defenses and automatically lose by a default final judgment. If the eviction is for cause and it's not based on non-payment of lot rent, there is no requirement to deposit lot rent into the court registry. I mean, in all the evictions that are for cause, it's important to file a notice of no requirement to deposit rent and cite to the statute. There's a circuit court split as to whether or not the court actually has authority to order a defendant in this type of eviction to make court registry deposits. But, regardless, it's best if you're representing a tenant who is being evicted from a mobile home park for cause, not for non-payment of rent, uh, file a notice of no requirement to deposit rent, try to make that argument to the judge, and instead have the tenant deposit into the trust account. Because, it's important to follow the statutory scheme and not fall into having a mobile homeowner have to make the rent deposit requirement when they don't need to under the statute, because that can lead to a default judgment. And it's better to practice what the statutory scheme puts forward. No registry deposits if it's a for cause eviction. What happens to a mobile home after eviction? If you are evicted from a mobile home park, but you own your mobile home, you can still remove it from the park and take it somewhere else. That's what's envisioned in the statute, in the Florida Mobile Home Act. But that's not really the reality for these older homes that can't be moved, or it's cost prohibitive to move a mobile home. Homes sometimes aren't mobile, especially if these additions are built onto them or they've been sitting on that platform for so long. There's lots of reasons why a mobile home cannot be moved. It's important to know that a mobile homeowner can sell a mobile home during the eviction and even after final judgment. But the new buyer must apply for residency in the park. Usually, if there's outstanding lot rent, then that new buyer might be responsible for paying it to the park, but it can be worked out. In fact, sometimes if a mobile homeowner is being evicted, and let's say they really did do the alleged violation, let's say the relationship with management is so bad that they want to leave anyway, a good resolution is to sell that person's home to the park for a fair price, or to find a new buyer, and that person can sell their home instead of losing it completely and move out with relocation funds. But they have a right to sell their mobile home at any point, even after a final judgment for eviction, so long as the home is not considered abandoned, which we'll talk about in a second. So under 723.058, a park cannot restrict the sale of a mobile home. This applies during the eviction process as well. And under 723.059, a park must approve an application if a buyer qualifies. The park cannot unreasonably withhold approval of a new purchaser, even during eviction. If a mobile home is considered abandoned, the park owner can place a storage lien on the mobile home, and the park owner gets title to the home, and usually they resell the home or rent it. The whole process is laid out in 723.084. It's too much to get into right now, but this is usually what happens. If a mobile homeowner is evicted, they will lose their home. They won't have the funds to relocate it. Maybe they didn't have a chance to sell it in time. And if that home is left on the lot after the writ is issued, that park owner has a means of placing a lien on the home, of getting title to the home, and of taking that person's mobile home if that person was evicted. It's really important to explain this to judges so they understand the weight of what a mobile home eviction means. Someone's taking you out of your home that you own. And if you can't take that home with you, you are losing your investment, you're losing your home, and that home actually becomes the property of the mobile home park operator. That's also a really great defense under equity abortive forfeiture for any kind of defense, for any kind of eviction. Okay, park sales, very quickly. Sale of mobile home park is regulated under 723.071. If a park owner offers a park for sale to the public, they have to notify an HOA board of the offer if there's an HOA in existence at the park, and they state the price and terms of the sale. Then the HOA has 45 days to meet those price and terms of the sale. So the HOA, in effect, has a right of first refusal to purchase a mobile home park if that park is being offered for sale to the public. What does offered for sale to the general public mean? That is a arguable issue. Actually, I'm in litigation right now over it, so I don't want to get into it too much. But basically, one way to look at it is if it's like a private deal where there was an unsolicited offer, and there was no announcement online or through, to the public at all about the park sale, then this might not be triggered. But if there is any kind of announcement that the park is being sold, then the HOA has the right of first refusal to purchase the park. Improper rent increases and decreases in park services. So a mobile home park operator can increase the lot rents of people in the park once a year. And there's a whole statutory process laid out in the Florida Mobile Home Act for how that can be done. But there's a sort of rent control that's worked in, because we mentioned this modern day feudalism, unequal power dynamic between landowner and homeowner. And because this home is, semi-permanent on this land, there has to be some sort of controls for rent. It's not as easy to just move around like an apartment situation. It's your home. It's not easy to move. So this was worked into the Florida statutes, where the park owner has to give a 90-day written notice before a rent increase goes into effect. A committee of 5 designated by a majority of homeowners, or if there's an HOA, just the HOA board of directors can designate a committee of 5 in writing. Once the committee of 5 homeowners is selected, then they make a written request to meet with the park owner. This has to be done quickly, because they have to meet once a committee is selected, and the park owner have to meet no later than 60 days before the effective date of change to discuss the reasons for the increase and any other issue. Now, I know we're lawyers, we're not super great at math, but 90 minus 60 means you have 30 days from the time of receiving the notice to gather signatures to designate this committee, to to dispute the rent increase, and to meet with the park owner. It's not a lot of time to get all of that done, especially if it's a mobile home park that's seasonal and half the homeowners are not there at the time. Okay, so once you meet with the park owner, if you're able to get to that point, the committee, the park owner at the first meeting with the committee, which happens 30 days after receiving the notice of rent increase, has to present to the committee all of the reasons for the justification of the rent increase. It could be an increase in operational costs. It can be that market rents in the area and other similar mobile home parks are much higher. Whatever reason they want to give, they have to present it to the committee of homeowners. Now, the committee of homeowners have 15 days after that meeting to make a disclosure of dispute in writing, explaining why they disagree with the park owner's evidence that they presented for justifying the rent increase, and they have to request another meeting. Then they meet a second time. And the whole point of this is to try to negotiate an acceptable amount of rent increase that will go into effect. So it's very difficult to actually come to a resolution at these types of meetings, but it's supposed to facilitate communication between the park owner and the designated homeowners committee. The park owner and the committee can agree to meet as many times as they want until a settlement is reached. But if they cannot reach a settlement after these meetings, then the homeowners committee must petition for mediation within 30 days of the last meeting. Petitioning for mediation means that you fill out a form, you gather signatures from a majority of homeowners that are affected by the rent increase, and you send it to the Florida Division of Mobile Homes. Once it's sent to the Florida Division of Mobile Homes, then they will designate a mediator, which both sides have to pay for. The fees are statutory, and it depends on which county you're in. And then you go to mediation and you try to resolve the rent dispute. So let's say in an ideal world, a park owner wants to raise rent by $50 a month and sends a 90-day notice of rent increase saying I'm increasing lot rent by $50 a month. The homeowners get together all the required signatures to dispute the rent increase. They select the committee of 5. They meet with the park owner. The park owner gives their reasons for wanting to increase the rent. The committee requests a second meeting, discloses their dispute for the rent. No resolution, they go to mediation, and at mediation, they come to an agreement that instead of accepting a $50 rent increase, they'll accept a $25 rent increase for the next year. And, they don't expect any improvements to be made to the park, something like that. That's like what this process envisions. But this can happen each year. So if you do have a situation where you're able to go to rent negotiations with a park owner, it's better to try to figure out a multi-year deal so you're not back at square one each year. And if mediation is unsuccessful, then the homeowners or a homeowners association has the ability to file a suit in court if they believe that the lot rent increase is unreasonable. Unreasonable means in excess of market rent. Market rent is not including apartment rentals. It is looking at mobile home parks with similar facilities, amenities, and services within the area. I'm also in litigation with one of these, actually with 2 cases with this right now. And there's not a lot of case law in Florida, at least recently, about rent disputes, about park closures, about a lot of things under the Florida Mobile Home Act. So it's kind of uncharted territory. Let's see here. So this can come up when it comes to rent increases. This can also be decreases in park services. So let's say there is a pool in a mobile home park. The park owner wants to take that pool away. They have to go through this 90-day notice period, the whole negotiation. That would apply. The same process would apply. Same thing with changes in rules or regulations. As I mentioned before, properly promulgated rules means that if there is a new rule, the park owner has to give a 90-day notice and has to go through this whole process before that rule can be implemented. Okay, I've mentioned HOAs, mobile homeowners associations, a couple of times. They're so important under the Florida Mobile Home Act because properly formed homeowners association can represent all homeowners in the park. What I'm talking about here is not the type of HOA that you would think of with like a condo that is responsible for the maintenance and operation of the mobile home park. That's not what I'm talking about here. Although those types of mobile homeowners associations do exist, what I'm talking about is just a group of mobile homeowners who want the protections of Chapter 723. They don't own the park. They're not responsible for maintenance and operation of the park. They just want to represent the common interests of all the mobile homeowners in the park. And they have a means to do so under the Florida Mobile Home Act. Under Chapter 723, as I mentioned, an existing HOA has the right to be notified of a park sale and the right to purchase the park. Super important right. They have the ability to challenge rent increases, decreases in park services, and changes in rules and regulations much quicker. Instead of getting a 90-day notice and having to collect the majority of homeowners' signatures to designate a committee of 5, if there's an HOA with an HOA board already in place, then only those 5 members on the board of directors of the HOA would need to sign a form to elect the committee of 5. It's much faster. And then the most important thing is that a homeowners association has the ability to sue on behalf of all homeowners, which is it's a right that's important for enforcing an issue that affects everyone. If you want to file a lawsuit, instead of filing a lawsuit on behalf of individually named homeowners. So an HOA under Florida Rule of Civil Procedure 1.222, basically it's like a quasi-class action rule where a mobile homeowners association can sue and can initiate litigation for matters of common interest. This comes into play with rent increases, decrease in park services, or flagrant violations by mobile home park operators that affect the interests of all the mobile homeowners in the same way. Apart from litigation and all of these legal rights, it's also just a great way to organize homeowners so that they have a formal means of negotiating with the park, especially during park closures. You know, down here in Miami, we've had 4 park closures in the past 3 years, and when you form HOAs and everyone has the ability to unify as a group, there's much more incentive for a park owner to enter a global settlement when they know that everyone's on the same page. So as I mentioned before, $1,375 in relocation funds in funds if you abandon your mobile home in a park closure situation. With an HOA recently in a mobile home park, we were able to get $10,000 per person because there was a guarantee that everyone was on board and everyone would leave by a deadline instead of the park owner having to file evictions against everyone. It's very powerful when there's a unified group of homeowners in a mobile home park. Provides framework for organized communication among the residents. You know, instead of 12 different residents marching into a park management office and yelling about something that they're upset about, they can convene, talk, and create a plan of action for how they want to engage park administration to have a better outcome. And like I said, formal relationship with park administration. I've mentioned quite a few war stories about, you know, abuses by park managers and park owners, but HOAs also have we have some really great relationships with park owners where if our residents are organized in a way where they respect one another and demand respect, they are going to receive a better outcome in their talks with park management. So I won't go through too many examples, but in quite a few parks, there's actually a really great relationship between the park management and the homeowners. And whenever there's an issue that arises, they work it out. And we've been able to come to agreements regarding code violations, agreements regarding things such as like tree trimming, things such as repairs to people's mobile homes that the park owner is not necessarily responsible for, but it's in the best interest of everyone for the owner and the homeowners to work together. And the only way that was possible was by an organized mobile homeowners association. Let me look at the time here. Oh, I'm over time. Okay, so I'm gonna go through this quickly. This is the steps for forming a HOA. We won't have to go through that. And I'm just going to leave this link up here. There's a whole, the Florida Division of Mobile Homes, you're able to get the prospectus agreements for each park, notices of lot rental increases, complaints. Like I mentioned, they handle petitions for mediation, and homeowners can file complaints against park owners. And the division has the power to investigate those complaints and violations. They don't have the authority to enforce the park owners' duty to maintain the park, but they do have the power to look at all these different kinds of violations of Chapter 23. They would send notices to the park owner about the violations. They can impose fines against park owners, and they can pursue enforcement of the penalty in court. So it's a very important tool for mobile homeowners, and you can get the link in this PowerPoint. Very quickly, the Florida Department of Health has a master list of all mobile home parks and RV parks in Florida. And the link is here. You can get a lot of good information from this list if you're dealing with a mobile home park, and it's updated each year. So I'm going to actually skip this section because it's too long, but the link that provides all the information you will want to know about consumer practices and buying a mobile home is found here on this slide, and Alice can send that out to everyone. So I'm just going to skip through this because all that information is found at that link. And finally, title issues in a mobile home park. A lot of times when people buy mobile homes, they don't actually get titles to the home. It's super important to have clear title for eviction defense, for relocation assistance, for disaster assistance, such as FEMA. The link for applying for title is there, but if you're located in North Florida, Legal Services of North Florida provides assistance with clearing title, and you can visit their website for more information on that. Alice, I know I went over time, so I'm not sure if we'll have time for questions, but if you want to open up, let me know. I'm just going to leave this CLE credit here, and thank you everyone for your time and for listening.
Thank you so much, Najla. We don't have time for questions. You may email, Nejla has kindly offered for anyone to email her and follow up with any of your questions. It was a pretty comprehensive discussion, but we did have a few questions, so please reach out to Nejla at Legal Services of Greater Miami. This webinar, again, will be at www.flpublicinterestlaw.org. You can go there, rewatch the webinar, look at Nejla's excellent PowerPoint. In that will be contained her contact information, and the CLE information will be there as well. Thank you so much for joining us. Look for information about our webinar next month on litigation with force-placed insurance, which will be on September 25th. Thank you all so much for joining us, and have a good afternoon.